Welcome back to Lost channel. My name is Anton Bieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to look at a case where agents of the ATF are trying to conduct a knock and talk. They come up to the front door and they tell the owner of the apartment that somebody has planted a bomb inside. Now the ATF later concedes that they did not have any reason to believe that there were any bombs inside, but they were simply trying to gain access to the property. Now once inside, they searched the apartment, found some firearms, and the owner of the apartment was charged with being felon in possession. He later argues that the consent to search his apartment was invalid or involuntary because of the deceitful tactics used by the ATF. So today we're going to look at what constitutes consent to search and when this consent becomes invalid, involuntary, because of some of these deceitful tactics used by the police. And before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Bieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States v. Harrison, and first let me give you some factual background. Agents of the ATF were investigating Mr. Harrison because they believed that he owed large amounts of money to a suspected gun trafficker and sold narcotics out of his apartment. For months, ATF agents were surveilling the apartment, trying to see if there's any evidence of drug trafficking. They came out empty-handed. They did not see any evidence of drug trafficking at Mr. Harrison's apartment. So after months, they make a decision to conduct a knock and talk. Now, I've discussed knock and talk many times on my channel. I have a list of cases that I will link in the description below. But essentially, a knock and talk is considered to be a consensual encounter between you and the police. Just like any citizen can come up to your front door and try to talk to you, so can the police. They can knock on your door and try to engage with you. Of course, there are exceptions if you put out gates, if you put up security cameras, and if you're not allowing the public to come up to your front door. But for the most part, if the public can come up to your front door, so can the police. So on this particular day, ATF agents came up to Mr. Harrison's door. They knocked on it. They were wearing plain clothes, but they had their ATF badges as necklaces. They had firearms, but those were hidden. They knocked on the door, and Mr. Harrison answered. "Who is it?" One of the agents simply responded, "It's Steve." For the next 3 minutes, there was silence. Nobody was opening the door, so the agents continued to knock. After 3 minutes, Mr. Harrison opened the door. The agents introduced themselves as law enforcement, and they told him that they believed that there were drugs and bombs inside the apartment. Now, the government later conceded that the ATF did not have any reason to believe that there were any bombs inside the apartment. Nevertheless, the agents lied and told the owner of the apartment, Mr. Harrison, that there were bombs inside. Now, they told Mr. Harrison that they wanted to go inside the apartment. They had bigger fish to fry. They were not trying to get him for any marijuana or anything else. They were simply trying to look for bombs. Because if they get calls like that are anonymous about the bombs, for the safety of others, they always go inside to check things out. Now, Mr. Harrison at first said that he didn't even know if he could consent to a search. After all, the apartment technically belonged to his girlfriend. Now, the ATF agents explained to Mr. Harrison that if he lived there, he could consent. So he led the agents inside his apartment. They looked around and they found a firearm. Mr. Harrison is later charged with being a felon in possession of a firearm under 18 U.S.C. 922 G1. Now, he later argues that the firearm has to be suppressed and cannot be used against him because he says that the search was not voluntary. He did not give consent to that search. Now, we know that warrantless searches are deemed and per se unreasonable under the Fourth Amendment. But of course, there are exceptions to any rules, and one of those exceptions is a voluntary consent. But the Fourth and 14th Amendments require that a consent not be coerced by explicit or implicit means, by implied threat or covert force. For no matter how subtly the coercion was applied, the resulting consent would be no more than a pretext for unjustified police intrusion against which the Fourth Amendment is directed. The government bears the burden of proving that consent is given freely and voluntarily. The question whether a consent to a search was in fact voluntary or was the product of duress or coercion, express or implied, is a question of fact to be determined from the totality of circumstances. Relevant considerations include physical mistreatment, use of force, threats, promises, inducements, deception, trickery, or an aggressive tone, the physical and mental condition and capacity of the defendant, the number of officers on the scene, and the display of police weapons. Whether an officer reads a defendant his Miranda rights, obtains consent pursuant to a claim of lawful authority, or informs a defendant of his or her right to refuse consent also are factors to consider in determining whether consent given was voluntary under the totality of circumstances. So let's look through some of these factors. The government first contends that the search of Mr. Harrison's apartment was reasonable because the courts have long held that law enforcement can use deception to gain entry into people's residences. It is true that not all deception and trickery would render a search invalid. Think of an example of undercover work. Of course, the general public allows officers to wear plain clothes, to do undercover work, and even gain entry into people's homes in order to purchase narcotics from a suspected drug dealers. This is a type of work that's undercover, and of course, it's a type of deception and trickery, but the Fourth Amendment allows it. But not all trickery and deception is the same. And here the court reminds us that Mr. Harrison, in fact, knew that these were ATF agents. This was not undercover work. And the court says that we have to be especially careful when law enforcement uses trickery and deceit to make an individual feel unsafe if he refuses consent to a search. Telling an individual that somebody might have planted a bomb inside his apartment is a type of trickery that's different from undercover work. Here, the individual would feel that he's unsafe if he does not consent to a search. On to the second factor. Although the government agents are not required to tell the individual that he has a right to refuse consent to a search, the opposite is not true. It would be deemed coercive if the agents imply that the individual has no right to refuse consent to a search. Now, in this situation, Mr. Harrison could have reasonably believed that somebody planted a bomb in his apartment, and he would have been left with two options. Option number one is live with the risk that somebody planted a bomb in his apartment and refuse the search, or do what a reasonable person would do in that situation and consent to a search. Now, under these circumstances, the court says this was a coercive conduct by the police because it implied that Mr. Harrison had no right to refuse the consent to a search. Because after all, no reasonable person would live with that type of risk. And finally, the government argues that consent was voluntary because there was no evidence to suggest that Mr. Harrison felt coerced by the statements of law enforcement. After all, Mr. Harrison stayed inside his apartment during the search of it. He did not feel threatened. But the court says the fact that Mr. Harrison stayed in his apartment did not indicate whether he was threatened or not. It might be because of the agent's demeanor, the fact that they were calm, wearing plain clothes, walking through the apartment, that he might have felt safe in the moment. But if the agents would have called backup and more officers arrived in a bomb squad gear, Mr. Harrison might have felt otherwise. He might have felt scared at that point. So it might be just the combination of circumstances. But it doesn't mean that he wasn't feeling threatened. And even if we look at the subjective state of mind of Mr. Harrison, the court says that if you combine all of these factors, at the end of the day, there was coercion. And that means that the consent to search was not given voluntarily. And at the end of the day, it also means that the firearm that was seized has to be suppressed and cannot be used against Mr. Harrison in trial, which means that the felon in possession would be dismissed because there is no firearm. If you learned something today about coercion, about how consent to search a house works, and what type of trickery can be used by law enforcement, and what kind of trickery really makes the search invalid, I hope you click like on this video, hit that subscribe button, share my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.